If the other parent isn't complying with requirements of the parenting plan or is withholding the child from you, there are certain avenues you can do to kind of remedy it with the court. First and foremost, I would say try to keep a record, either via email or text, something in writing that you can kind of, let's say, catch the other parent saying that they're not going to comply with the parenting plan. But you can file a motion for contempt, for make-up timesharing, for enforcement, and essentially bring that person before the judge and have him or her explain why he or she is failing to give you timesharing with the child. If the other parent has unreasonably withheld timesharing, then the court can offer you make-up timesharing that would normally be reserved for the other parent. So there's always a remedy out there to try to enforce compliance with the parenting plan so the other parent isn't, unreasonably withholding. There's also what's known as a child pickup order that you can file a motion for. But these are essentially reserved for situations where there's some kind of emergency or some imminent harm or danger of abuse, abandonment, neglect, and so forth. So those are relatively sparingly used, but there's always a remedy to enforce a parenting plan. In the interest of co-parenting, however, I do find that it's helpful or beneficial to at least try to work it out, kind of an informal mediation in terms of co-parenting to try to get them to give the child over, but if not, then at least get it in writing so you can have proof to the court rather than just your testimony. Say, look, he sent me an email saying he's not going to bring our daughter back because he just doesn't want to. Yes, you can change a parenting plan. You can change time-sharing schedule, you could change child support, both of which will be encapsulated in the parenting plan. The standard under Florida law for changing or modifying a parenting plan, time-sharing schedule, or child support obligation is a substantial, material, and unanticipated change of circumstances. And the modification must also represent the best interest of the child. There's no presumption in favor of 50-50 time sharing or more time sharing with the mother. It's a strict best interest of the child analysis. But let's say you have a parenting plan, the father, he fails to exercise his time sharing. He's like, he has every other weekend, but it's been 6 months and he hasn't come by to pick up your son or daughter. At that point, there's been a substantial change of circumstances, which is unanticipated and it's material. So this is a sufficient basis for filing a modification for the time-sharing schedule. And if you modify the time-sharing schedule, then more likely than not, you're also going to be able to modify the child support. Florida Statute 61.30 requires that a modification of child support has to be at least 15% or $50 per month, whichever is greater. So those are kind of looped in together because child support is based on what the time-sharing schedule is, among other factors. Yes, your parenting plan will always have some provisions in terms of the holidays and for what the time sharing is going to be. Now, first and foremost, let's say you have a time sharing schedule that's 50-50, week on, week off. The mother takes the child for the first week, then it's the father, then the second week, and it's on a rotating basis. The most important thing to remember is that the holiday time-sharing schedule will supersede or override any other regular time-sharing schedule. So that week-on, week-off kind of scenario is not going to apply during the holiday season. Now, what happens a lot of times is that there's kind of an alternating or a rotating basis for time-sharing during the holiday season. Maybe the mother gets Thanksgiving this year, and then the father gets the first half of Christmas, then the mother gets the second half of Christmas, plus New Year's, and then the father gets spring break, but the mother gets Easter. The next year, that'll flip. So there's always kind of this rotating basis, and that's just kind of the default. I mean, it's up to the parents a lot of times to decide between themselves what the parenting plan will be for the holiday schedules. Hi, my name is Kevin Vagovic. I'm an attorney in Daytona Beach, focusing on criminal defense, family law, and general civil litigation. Visit us on the web at vagoviclaw.com or give us a call at 386-265-0900.